National Resistance Movement is Farida Nambi Chigongo still awaits to challenge the National Unity Platform Elias Luyimba's Nalukoola's victory. In Kawempe North Member of Parliament, Farida Nambi Chigongo filed the petition against Elias Luyimba's Nalukoola and the Electoral Commission, alleging election illegalities. During the last court sitting, Nalukoola's legal team asked court to allow them cross-examine all the 31 witnesses presented to court by NRM's Farida Nambi Chigongo, to which Nambi's legal team objected. The presiding judge, Bernard Namanya, dismissed the application.
This morning, there is a Sagara Kudam.
Moze mujjukidde tugende Moze nti olunamala kansonga omuzaamu.
This morning the court has dismissed Nalukoola's application for leave to appeal against its decision disallowing the prayer for cross-examination of all of our witnesses. Last week on Thursday, Nalukoola and his legal team applied to cross-examine all 31 of our witnesses. We argued then that it was not necessary to cross-examine all of our witnesses. Why? Because majority of our witnesses, what they say is what Nalukoola has said in his defense. Principally, majority of our witnesses are saying that there were no results from 14 polling stations, which is our ground one in the petition. In Nalukoola's answer, he stated that it is true there were no results from those 14 polling stations. That answer was also repeated by the Electoral Commission, which stated in no unclear terms that there were no results from those 14 polling stations. The question now was, if all parties agree that in these 14 polling stations there were no results, what then should be the reason for cross-examining these witnesses when everybody agrees to what we are stating in our petition?
In the court's ruling, court allowed Nambi to cross-examine 6 witnesses from the respondents, and Nalukoola's legal team will cross-examine 10 witnesses out of 31 witnesses from Nambi's side.
It's a rough ride. Today, the court has denied us the opportunity to appeal against its decision, which we thought was causing a miscarriage and a mistrial in this matter. We continue to have faceless witnesses. The law provides that any witness has to disclose themselves by attaching the national ID. We asked court that so many of these witnesses, if not all, are faceless. They are like ghost witnesses. Exercise your discretion to call them to court to see whether we can put face to name. That is the purpose of cross-examination in such matters. But court has insisted it does not want to see these people. That was against the background that some of those witnesses, who are now 2 of our witnesses, denied having provided any case, any evidence to the lawyers and to the petitioner. So we believed by calling for these witnesses, court will be satisfied if these actually signed not. But the court, at the altar of expediting the trial, it has denied. That's the reason that court is bound to conclude this matter within 30 days. If you have 30 days, I know we are bound to respect the decision. But if you have 30 days, why do you limit the trial to 3 days? We have 30 days, then you have given us only 3 days within which. So, we believe there may still be a miscarriage. Justice hurried is justice miscarriage. If we could have the 16 witnesses in 3 days, like he has determined, it means we could have the 30 in 20 or so days, which would still be within the time frame as provided for by court. And we know in history I have not seen any trial rushed like this one.
Justice should not be delayed, but still justice should not be rushed. Yes, we respect the judge, but we do not agree with his decision to bar us from cross-examining those witnesses.
Nalukoola's legal team, however, expressed concern towards court for not allowing them to cross-examine all the 31 witnesses presented to court by Nambi.
We've been in over 60 election petitions, maybe even 100 petitions. There's not been any election petition as hurried as this one. That is why we have a question as to why the rush. But we are ready. Nevertheless, as lawyers, that's the order of court. We shall provide our witnesses, and we are ready to cross-examine those that are brought before us. Note that the decision to deny us leave to appeal means we do not have any win. These are matters we are going to venture into as lawyers, because now it's a matter of strategy. It's a roller coaster. We are going into it, and we are up to the task. So tomorrow we are here to do our work. But at the end of the day, we believe it should be fair that this matter should be handled as a matter of public importance. It's not a matter of the Honorable Nalukoola. It's not a matter of Nambi. It's a matter of the people of Kawempe and Ugandans. A matter where there are such gruesome offenses, such violence against our people. The same violence orchestrated by those who are now bringing us to court to use the same violence to benefit them. And we take that as a simple matter. We shall not. We are going to put in all that we can as lawyers to ensure that we win. We win by obtaining a dismissal of this matter.
I'm glad that court, by the nature of electoral petitions, has not played into Nalukoola and his lawyers. Because last time when we were here on Friday, we saw that they were trying to delay the process of court for as much as they could, because they even tried to apply for appeal when a case had not even a single witness had come to court to be cross-examined. So we saw that there was a delay tactic, and our prayer to the lawyers was that the judge, since we're already in so many days, we've gone so many days on this petition, he should allow us to work within the 30 days of the law.
Kawempe North Member of Parliament Elias Luyimbazi in Nalukoola was not pleased with the way court has handled the petition.
No Nambi at trial. It is the judge himself. Nambi is aware that she wanted to cheat my victory. She brought men and women who caused the havoc in Kawempe North constituency. But the voters themselves stood firm against such violences. And we ended up having the victory. Now Nambi is laboring in futility to use courts and take away our victory. It is the judge at trial now, because Nambi is aware that she has nothing in the Kawempe North constituency. I'm aware that I won. It was a clean victory amidst the wrongdoings by Museveni and his men, together with Nambi. Now the judge has denied us the opportunity to milk justice out of those liars. You are aware that they came up with deceit, falsehood, to the effect that Nalukoola bribed the voters, which is not true. We want to pose questions to those people. The judge has denied us that opportunity. It is wrong. It is wrong. We don't have to pretend that we are appreciative, that we agree with that decision. We disagree, but with great respect to courts. Let me have a discussion with our lawyers. We shall find remedies. But
clearly, for them, it has been a delay tactic. Everybody, first of all, I want to say sorry again for all you journalists that were hurt during that by-election, and I've stated it that I, as Nambi, I am not party to any security agency harassing or beating people or harming people in any way. I have said this before because I've heard him here trying to say that I commanded or I directed people to harm and hurt people of Kawempe North. That is not true. That is just political propaganda. And I have even personally visited some of them that were hurt and expressed things that I cannot even express here in the media.
Judge Bernardine Namanya set 13th May 2025 to start the full hearing of the petition.
Unprincipled as they are, in trying to delay this matter, playing all manner of games, Nalukoola's lawyers pray to the court, they apply to the court to appeal against that decision. We again argued back then that it is not necessary. Why? Because the law does not permit Nalukoola to appeal against interlocutory decisions of the High Court when it is hearing an election petition. The appeal is only allowed once the full petition has been heard and determined. We are happy this morning that the court has agreed with us and dismissed that application for leave to appeal against those interlocutory decisions. We shall now go ahead to present all our witnesses as directed by the court tomorrow morning and on Wednesday morning, and hope that when our turn comes for Nalukoola to bring his witnesses, he will be able to bring them on Thursday. As to whether this matter is proceeding fast, that is a requirement of the law. Rule 13 of the Parliamentary Election Petitions Rules requires that the petition is heard and determined within 30 days from the date the hearing starts. This hearing, the consideration of this petition, started on the 30th of April. Today is 12th May, and we have therefore already used 12 days. We have 18 days to go, in which we must do everything. That is to say, cross-examine witnesses, re-examine them, file final submissions, and also get judgment, all in the next 18 days. So we don't have time. What the court has done is what the law allows it to do, what the law commands it to do. So that's what we shall do, and by the end of the week, hopefully, we'll be done with the examination of witnesses and we proceed with other steps in the trial of the petition.
Thank you. Honorable.
In the last Kawempe North constituency by-elections, Elias Luyimbaz in Nalukoola won the elections with 17,764 votes, while NRM's Farida Nambi Chigongo got 8,593 votes.